Sakshi Telugu Prajalu Mana Sakshi special immigration show ki swagatam suswagatam. Today we are back with our expert attorney Bhanu B. Illindra garu, BBI Law Group PC 17 of experience in law offices. And if you have any questions regarding immigration, please feel call to us and Bhanu garu will glad to answer your questions. So before we begin the show, please note that the information provided on the show not a legal advice. It's just for information purpose only. So Sakshi TV or its agents will not be responsible for this. If you need any specific legal advice, please contact the attorney directly. And before we begin the show, Bhanu garu to maatladidam. Hello Bhanu garu.
Hello Andy, how are you Prasanna garu?
Yes guys, I'm good Bhanu garu. Thank you. Bhanu garu, so manam షో స్టార్ట్ చేసే ముందు వన్స్ అగైన్ మీరు లా ఆఫీసెస్ ఎక్స్పీరియన్సెస్ అండ్ ఆల్సో లీగల్ అడ్వైస్ ఇన్ఫర్మేషన్ అవన్నీ మా వ్యూయర్స్ కోసం తెలియజేస్తారు.
Sure Andy, thank you very much for giving this opportunity. My name is Bhanu Illindra Andy, Bhanu Babu Illindra. Basically I'm an immigration attorney practicing for almost 17 years in this country in immigration law, and my firm name is BBI Law Group PC. I'm the founder of the firm basically, and we are running operations from 2008, my own firm basically, and we represent exclusively in immigration law matters only, and we have represented in hundreds and thousands of matters, immigration matters, especially in business immigration law, family-based immigration laws, and we even implement, we do investor visa matters basically also, and then we do certain very few asylum cases, few refugee cases, few removal proceeding cases basically, but most of our practice comes from the employment-based immigration and also from the family-based immigration basically. So we have experience in representing all types of immigration matters. Recently, we expanded our services for the consular processings also. Like for example, if somebody is going for a visa abroad, like in India or in Canada or anything like that, we'll be very happy to help them with the paperwork and everything. And also we represent ourselves as an attorneys at the consulates also basically. And that's what it is. Our firm website is www.bblawgroup.com. Please visit our website so that you all can see what the information we have, what we do and everything. And if you want to reach us basically, our contact details are there in our website. And also for your convenience, I'm providing them here. Our office number is 703-496-7722. Our email ID is bhanu@bblawgroup.com or contact@bblawgroup.com, or they can also send an email to crm@bblawgroup.com. And thanks for giving this opportunity again, Sakshi TV and entire team of the Sakshi TV and
Thank you, Bhanu garu. Thanks for the info. And before we get into the topic, we have some callers. Let's take first caller. Shekhar from Shekhar, please go on.
Hello, this is Shekhar. So my question is, currently I'm on H1B. And I don't have stamping on my passport, but my extension is available. I applied for EB3 downgrade. Let's say if I get the EB3 EAD and advanced payroll, and if I travel to India, while coming back, I came to know that I can use the advanced payroll to come back from India to US. If I come, it's people are saying is that it is better to have a visa stamping as well. Is that really required? And once I come back, can I stay on H1B I-94 without stamping on the passport?
If you come back on advanced payroll, then you're entering into this country as a parolee, not as a H1B visa holder. So if you come back on parole, then obviously you have to have EAD approved for you in order to work in this country legally. Okay. If you want to maintain your H1B status, then you need to go for the stamping and enter on H1B visa into this country. And that's the disadvantage you have if you come on advance payroll. That means you cannot maintain your H1B status. But I don't see any harm you staying as an adjustee also in this country. Also, it's preferable to have an H1B status at the same time while your I-140 and 485 is pending. If once your I-140 is approved, I think taking the risk of not having any other lawful non-immigrant status in this country should be okay, because you should be able to adjust status in this country, barring no other prohibitions for you to adjust your status in this country. But That's only the thing. Unfortunately, if you come back on advance parole, you'll be entering as a parolee rather than as a H-1B non-immigrant worker. Therefore, you cannot maintain, you are no longer on H-1B visa status.
Right. Thanks for calling, Shekhar. And next we have Raju from California. Raju, please go on.
Hello.
Yes, chip in.
Yeah. So my question, thank you. And my question is like, so after the last paycheck, how long can we stay in this country in H-1B?
What do you mean by last paycheck? I'm not able to understand what do you mean by that.
I mean, like, so recently I've resigned from a company, and my last paycheck was on January 30th. So how long I'm eligible to stay in this country for new job search?
Sir, it is not the paycheck, sir. It's the last date of your employment with your employer. The date of your resignation
both
may
are
be...
same.
Yeah, if the both are same, and if you have a valid I-94 for that H-1B, and you have never used the 60-day grace period in the past, maybe you will be eligible for the 60-day grace period, depending upon when your I-94 is expiring. 60-day grace period, or basically 60-day grace period, or the date whenever your I-94 expires, whichever is earlier. That is the period you can stay in this country, basically. From the date of your resignation, that is the last date of your employment. And from there, maybe if you're eligible for 60-day grace period, the 60-day grace period may commence on that. You have to depart the country within those 60 days, basically, or either you have to file for a transfer or change of status to some other status prior to the expiration of those 60-day grace period.
Right. Thanks for calling. Bhanu garu, before we get to the topic, I think we have some latest update on immigration reform bill, right? So can you brief with us?
Yeah, basically, as we all discussed that President Biden on his first day of administration, he sent a proposal to the Congress about the Citizenship Act of 2021. Basically, that's a comprehensive immigration reform. Many pundits say that it's a very ambitious bill, basically proposal by the current administration. And the proposal, actually, whatever the President Biden intended to provide for the immigrants, that proposal actually has been drafted into the statute and to the act, and that act has been introduced in the both chambers of the Congress, in the both chambers, basically. That's in the House and also in the Senate at the same time. And both are identical bills. There are no differences between the Senate bill and also in the House bill. And both are called Citizenship Act of 2021. The good thing about this bill is basically is that it addresses many issues what actually the many immigrants and non-immigrants are facing in this country, basically, right? It try to solve those issues for them, basically. It's a very positive statute, basically, if it comes to immigration. But I'm not sure whether whether they will be able to whether they'll be able to pass this one into the law. We do not know that, basically, because it has just been introduced. There's still several processes to go. We do not know whether in the end it will be in the same way or not, or whatever it is, basically, right? But this bill mainly addresses what it addresses, basically, is that it gives a path to citizenship for the up to maybe around 11 million unlawfully present immigrants in this country, basically. It's an 8-year path to citizenship, basically. Whoever physically present as of January 1, 2021 in the United States will be eligible under this category, provided they meet certain conditions and pass certain background checks and everything. And they'll be able to eligible for this. They'll given a special status for 5 years, and then they'll be given permanent residency after 5 years. And after 3 years of permanent residency, they'll be eligible for the filing for the naturalization. That is one big thing, basically. That gives relief for the DACA recipients, basically. That gives relief for the agricultural farm workers, basically, who are unlawfully staying in this country, as long as they can establish that they've been working in this country as a farm workers and everything. That's a very important thing. And second thing, obviously, we all very, very important for us from India, people from India and everybody, is that what's going to do with the backlog of the visas and everything, and what's going to be happening with the H4 visas, what's going to happen with the H1B visas. and what's going to happen with L1 visas. All those things are being considered and worried and everything. Good thing about that is basically is that they are going to give work permit for H4 visa holders from the day one. They do not have to wait until the husband getting an I-140 approval and everything. That's one good proposal is there for H4 visa holders in this. Along with that, basically, what they have done is basically is that they're removing the per country visa allocation system in this particular bill. Basically, they said that it's not that way. Whoever is coming into this country, they'll be able to apply for visas and everything. And also basically is that in the employment-based green card category, we have only 140,000 visas available. That 140,000 visas will be counted towards only the principal beneficiary, not the dependents basically. And that is also a very good proposal. And also another thing which has been included in this bill is recapturing all unused visa numbers because of the bureaucratic delay in adjudication of the green cards for the individuals and everything. That is also proposal is there in this basically. And along with that, basically, they were also actually, along with that, they are actually giving the several other things basically, right? Like, for example, that is one important thing basically. And also, if it comes to the family-based, I'm just giving a just study basically. And also for the family-based immigration, basically, what they propose is that now, permanent resident spouses and children are not immediate relatives. Only US citizen children and spouses are immediate relatives, and parents are immediate relatives. Now, they are going to include, as per this statute, is that permanent residents, children and spouses also as immediate relatives, basically. That's a significant change from existing laws, basically. That really helps a lot of people from India or from other countries also who are being permanent residents in this country and they're trying to marry somebody in India. They do not have to wait for the visa number allocation or anything like that because they're immediate relatives. They're immediately eligible to get a green card into this country. So that is one thing which is very, very important in this regulation, basically. And other things are basically is that diversity lottery, right? Even diversity lotteries, they're increasing the number. Basically, usually there were 55,000. I don't remember the exact number. They're increasing it to more than 80 or around 85,000 visas per year for the diversity lottery also. So they're trying to basically address all the issues that are actually bothering the immigrants in this country who wants to migrate to this country lawfully and work lawfully into this country and everything. And this is the gist of the bill. I'm not going into more details into it because of the lack of the time we have. I'm just giving on the gist and basically.
Yes, Bhanu, before we jump into the general immigration questions part 2, let's take another caller. Raju? Mm-hmm. Hello, sir. Please go on.
Yeah, thank you. My question is H-1B candidates are eligible to receive any unemployment benefits from the government?
Sir, the regulations never say that H-1B employees are not eligible for the unemployment benefits. But the whole issue comes is basically is that H-1B employees cannot stay unlawfully in this country. That means if they don't have an employment, they're out of status automatically, basically. Okay, and also unemployment benefit laws are actually determined by the state governments. Each and every state has its own unemployment laws, basically, and many states require for somebody who's applying for unemployment benefits that they actually provide the proof that they are maintaining valid immigrant status in this country, right? Either they are green card holders or there are some other visas and everything and all those things. That's why anybody who's an H-1B visa or L1 visa is generally considered not eligible for unemployment benefits because they cannot show that they're in valid legal status at the time they applied for unemployment benefits, because if they lose the job, they're no longer in valid status, basically. That's the whole thing.
Yes, right. Mm-hmm. Thanks for calling, Raju. So, Bhanu, what are the changes proposed under the employment-based green card areas like, EB1, EB2, EB3?
As I said, the changes basically provided is there are few more visas have been allocated for the other worker categories, basically. Previously, there were only 10,000 visas available for them. Now, that number has been increased. I do not recollect exactly what is the number for that is basically, but the number have been increased for other workers category. And a second thing is, as I said, is basically is that they're removing the per country limitation for the visa allocations for the employment-based green card categories. For example, right now, we have a per country limitation, how many visas can be issued per country nationals. For example, only 7% of total 140,000 visas can be allocated to each country right now, basically, each country nationality. For example, if people are from India, they can only get 7% of the 140,000 visas as of now, and also in that 7%, you're including not only the principal beneficiary who's coming into this country to work, but also their spouse, their children, everybody in that. Now, that has been changed. Basically, now that 140,000 visas are available to all the individuals, or only the principal beneficiaries. The dependents and spouses are not included to count towards that 140,000 number as per this statute, which has been introduced in both the chambers, basically that is in the House and in the Senate. We do not know whether that will happen or not, whether it will pass, it will become a law or not, but that's a very good welcoming change. And other proposal which they have is that, as I said before, retrieving all the immigrant visas that have been not used or not allocated in the past because of the bureaucratic delay in adjudication of green card applications or petitions, basically by the USCIS as well as the Department of State, basically, right? So there are a number of hundreds of thousands of visas have not been utilized in the past for several years, basically. They want to recapture all those visas, so that what happens is if they recapture all those visas and allocate to the coming cases, then the entire backlog can be eliminated, basically, because of that. So that's a very good proposal is there for the employment-based green card in category in this proposal, basically. And if this bill passes like this, I mean, that's a dream come true for any immigrant, basically. That's what I would say. But I'm not sure exactly whether that will happen or not, because of the policy compromises or policy issues with the both aisles of the Congress, that is between the Democrats and the Republicans, basically, and how it's going to go in the Senate and also in the House is a big thing. It may go through in the House because they have a majority, but in the Senate, they require at least 10 members of Republican senators votes also, along with the 50 members of the Democratic representatives to get this bill passed, which could be a very, very hard task, basically, for the Senate to go through the process. But it's pretty good, actually.
Yes, Bhanu, we have another caller, SP from Arizona. SP, please go on.
Yeah, hello?
Yes, sir.
Yeah, are you able to hear me?
Yeah.
Yes.
Yeah, hi. Okay, I'm watching in the TV. Yeah, it doesn't show this thing. Maybe there's a lag there. Okay. All right. Hi, Bhanu, how are you?
I'm fine, thank
good
you.
Question for you. So it can be a very generic question to you, but for us, like as a family, just want to get your opinion here. So we have our H1 extension coming up this year, and we want to have an F1 change of status for our kid. So just want to get your perspective. I mean, which one should we start first, or can both go in parallel? Because right now the whole process is taking such a long time. Right. So should we just start with the extensions first, and then once that is done in premium, then go for the change of status? And what should we put that for that question, right? Where that's the tricky question for F1, that immigrant intent or whatnot, right? So I just want to hear your thoughts. What is the best approach here?
You said that you're applying for the H4 extension, right? Basically for the person, or H1 extension for the individual? I didn't understand.
Right. Yeah. So I think our H1 and H4 extensions are coming up this year. And we also have a plan to change, into the F1 change of status for our kid. So the question is like, which one should we start first, and what should we put it in that question where in the F1 form they ask for that immigrant intent, right? So it's a tricky question. I want to get your professional opinion.
There is no, in 539, they don't ask you about the immigrant intent. What they ask you is that, have they ever filed any immigrant petition on your behalf, basically? And unless she filed I-485, if anybody files I-140 on her behalf, that question will not be applicable to her, basically. Okay, so you'll answer no to that question automatically because she's not the main beneficiary of any I-140 petition or I-130 petition, basically. If she is a beneficiary of I-130 petition or I-140 petition, then you will say yes to that answer for that question, basically. And second thing is basically is that I do not know the reason why she wants to convert into F1. Maybe she's aging out. If she's becoming 21 years old, then she's required to go on F1 visa. Otherwise, she can continue studying on H4 visa as long as she wants, basically, until she reaches 21 years of age, basically. And if she's aging out, then I would say that is that you can file H4 extension, basically, but at the same time, once you file H4 extension, then file for F1 change of status, because in order to file F1 change of status and the F1 change of status to be approved, what USCIS looks into is that whether the individual is maintaining valid status at the time the change of status is approved or adjudicated, basically. So they have to continuously maintain not only at the time of filing, but also at the time of adjudication or at the time of approval or decision of this particular F1 change of status application. So I would always prefer filing an alternative application also, whether it's for H4 or a B1, B2, along with the F1, so that will act as a bridge application for the F1 change of status to be approved, especially these days, because F1 change of status applications are taking almost a year. I mean, they're taking almost a year. So it's a very long time from the day you file for F1 change of status until the date F1 change of status is approved. Hope I answered the questions properly with what you asked. And if you have any other questions, kindly feel free to reach us privately. Very happy to guide you properly on this.
Yes, thanks for calling. Yes, it's time to talk some general immigration questions, Bhanu garu. So what are some factors that are considered by the US Citizenship and Immigrant Services, USCIS, is granting an individual immigration status?
I didn't get your question, Andy. Can you repeat the question? I'm sorry.
Okay, yeah, sure. I think we have another caller. Let's say the caller. Hello?
Sure.
Hello?
Hello. You're able to hear me?
Yes.
Yeah.
You can hear.
Yeah, so my question is after the 60 days grace period, if two petitions are filed by two different consultants, if one get rejected and another one is still progress, is H1B candidates are legal to stay in the country?
It all depends upon whom he joined and whom is he working with. Just filing a petition does not make them legal in this country. They have to join that employer as well within those 60-day grace period. And they have to start working with that employer within those 60-day grace period, basically. Right? So it all depends upon whom did they join, whom did they work, basically, whom are they working with. And those things will matter, whose case has been denied, whose case has been adjudicated, and whether they're maintaining valid status or not. It all depends upon that.
Right. Thanks for calling. And Bhanu garu, my question is, what are some factors that are considered by the USCIS in granting an individual immigration status?
There are a lot of factors, Andy. There are individually, they basically look into the individual's background checks, basically. They see the name checks, they see any criminal records they have, anything like that, or whether they have violated any immigration status in the past, or did they provide any falsifying documents to seek immigration benefits in the country, and whether they have a good moral character, whether they're subject to if they're looking for a green card, they look into is that whether they're going to be depending upon the US government to financially substantiate them or anything like that. They're very likely to become a public charge or not in the United States. These are the general factors which they look into, basically, for anybody coming into this country. And it varies from application to application. It varies from degree of background checks varies from application to application. For example, if you do a H1B visa application, H1B petition, basically, the background check level for the H1B petition will be different level for the green card application and for the naturalization application. For the naturalization application, it will be even more severe background checks, basically. They go through in more detail exactly to look into where is he coming from, what is his education is from, which colleges is gone. They're going to look into all the background when you're applying for naturalization. It's going to be more vigorous and extensive background checks going to happen when you do naturalization application. So It depends upon, as I said. But as I said, these are the basic things which they look into basically.
Right, Bhanu, we have another caller from Pennsylvania. Rakesh, please go on.
Yes, thank you for taking my call. So we applied for AOS 131 and 7 EAD, October EB3 to EB2. Me and my wife. My wife is a dependent. So my question is, if my wife misses the biometrics, I heard her all applications will be cancelled. Is that correct first? And the next question is, if that happens and my AOS, EAD, and AP are approved, can I be on that status? And what will happen to my wife's status? She's on H4 now. How we can have a dependent visa for her if I am on EAD and AP and if her applications are denied? Is it possible?
So basically, you have because of the COVID-19, I do not know exactly how the application support centers are operating across the country, basically. But in the past, before the COVID-19 pandemic, if you miss your appointment for the biometrics, especially for the AOS biometrics, adjustment of status application biometrics, basically, you still have 84 days to go back to the application support center and provide your biometrics, basically. You do not have to reschedule or take an appointment or anything like that, basically. Okay? And if you give that biometrics within those 84 days, from the date you missed your appointment, you are okay, right? Because they can continue processing your case without any denial for abandonment or anything like that, basically. Because of the COVID-19 pandemic, I do not know whether application support centers are allowing you to walk in and give the biometrics for these cases now across the country. That is the problem which I see right now. Basically, if somebody is going to miss an appointment, I think it's important to call the customer service and notify them in writing that they're basically would like to take a postponement they would like to change the date for the biometric appointment and everything like that. Otherwise, as you said, they will risk in getting denial, basically, for the abandonment. And if that happens, and if they don't have any other status in this country, you said, I think if I'm not wrong, I feel like I heard that you said that she has a valid H1B status right now, basically. Because H1B status is an independent status that has nothing to do with your status, basically. If that is a reason, if she's an H1B visa, then she'll be able to continue on H1B visa if her 485 and other applications filed for the adjustment of status along with you as a dependent gets denied for abandonment because she failed to provide or give biometrics as required by the OCS on a timely basis, basically. And as long as she has an H1B visa, as long as she can maintain H1B status, she's fine, basically. And you can be on a green card, you can be on adjustment of status, basically, as an adjustee in this country, and then you can work pursuant to your EAD and everything also, as long as she's not depending upon you. She's maintaining her own independent H1B status, basically. Otherwise, it's important that you get back onto H1B, and then she'll be able to stay in this country on H4 along with you. That's very, very important.
Yes, right. Thanks for calling. Right, Bhanu, we have another caller, Manoj from NC. Manoj, please go on.
Sure.
Hello.
Hello.
Question. For the my wife had her biometrics last year in the month of September, and we got our H4 visa in December. But again, we have to extend her H4 visa. So the question is, will there be another biometrics?
Yes. By the process, there will be another biometrics for her H4 extension, basically, yes. But whether they will take it or they won't take it, depending upon the USCIS. But yes, she has to go through again biometric process for the extension application, which she's going to file.
She's also applying for EAD extension. That means her EAD extension will be hold till she gets her biometrics done.
Our EAD will be held until her H4 is adjudicated. Basically, until her H4 extension is approved. Our eligibility for EAD is depending upon whether she has a valid H4 status in this country or not the biometrics.
Right. Our current EAD is expiring in January, and the extension we are looking for is next 1.5 year more.
No, I mean, we do not know how much time it's going to take. We do not know how much time it's going to take. I mean, I can't comment on that because the processing times can vary. Now it's taking time in some service centers like California and other places, but in other places it's faster, around 6 to 7 months, 7 to 8 months, depending upon which service center and other process, other things have been completed and everything. So it's very difficult for me to tell that it's going to take another 1.5 years. If it is going to take 1.5 years, it is going to take 1.5 years. And that's the reason why we did file lawsuits last year for the H4 applicants. We were able to successfully get those cases resolved and get their H4s and H4 EADs expeditiously because of filing lawsuits against the USCIS due to this undue delay happening for the H4 applications. Basically, we are planning to file one more also in coming weeks, basically in a week or two, and we already have quite a few people showing interest to file it collectively. And if people are interested in doing that, feel free to reach our office. We're very happy to discuss in detail how we can do this H4 litigation basically with the USCIS, and then we will be able to see if we can become one more collective plaintiff, lawsuit and everything. It's not going to be a class action lawsuit. If it's going to be a class action lawsuit, we have to have minimum 30 plaintiffs, but this is not going to be a class action lawsuit, but it's going to be all joint plaintiffs basically to file this lawsuit against the USCIS.
Yes. Thanks for calling in. Yes, Bhanu, so what is the difference between a finance visa and a marriage green card?
Fiancé visa you're talking about, right, Andy? Yes. Fiancé visa, basically, it's meant for the, if any US citizen basically gets engaged or decides to get married to a foreign citizen, basically, in order to go through that engagement process, basically, he can actually sponsor a fiancé visa, which is a fiancé visa, which is basically K1 visa. You file through form I-129F with the USCIS basically, right? And once you file the fiancé visa, the individual, once fiancé visa is approved, that individual will be able to come to US for the purpose of getting engaged and married to the fiancé, for the purpose of getting married to the fiancé who actually had an engagement with her prior to her coming to the US basically. And she has to get married within she or he, whoever it is basically, they have to get married within 90 days period of time once she enters into this country on a fiancé visa. Within 90 days, she has to get married. And then after that, within those 90 days, once she gets married, they can actually file for just I-130 and 485 as an immediate relative spouse in this country, basically. So that's very, very important,
So yes, finally, before we wind up the show, as usual, final golden immigration message to our US Bhanu.
Just my final golden message will be now is I think, although we are seeing, although pundits are telling already this particular bill introduced in the Congress in the both chambers is dead on arrival in Senate, still there is a possibility that they can do some kind of an immigration reform basically. So my advice will be all people in this country who are waiting in the line to get the green cards basically is make a positive lobbying efforts. Do not make negative lobby effects saying that do not give H1Bs to other people until we get a green cards or anything like that. That is basically a very negative lobbying effort. It gives a very bad image about you, about other person. When you're talking about don't give H1Bs to other people, only we want to get H1Bs, we only have to stay in this country. That's a very bad impression gives about you. Whoever is doing that, basically, that's very ill advice they've given, very bad way of lobbying that, basically, So I think work hard on this, basically, and try to get this lobbying. Talk to your senators, talk to your congressmen, and ensure that you get this thing. Because America is a land of immigrants. It has been a land of immigrants all these years. Not a single person in this country has been, as not a native-born American family or origin. Everybody who are in this country, except Native Americans, are migrated from one part of the other world of this country. So it's important that we continue the tradition, we keep the tradition. That's only the way America can thrive and America can survive. So, and that's my humble advice, Andy, basically.
Thank you so much for spending your valuable time here. Thanks for joining us. Thank you.
Sure. Thank you, Prasanna garu. Thank you very much. Thank you very much, Sakshi TV and entire team for giving this opportunity again. And I'm really, really happy that I am also became a part of the Sakshi family. And humbly thank you. Thank you. Thank you.
ఇవాల్టి స్పెషల్ ఇమిగ్రేషన్ షో మరో ఎపిసోడ్ లో మళ్ళీ కలుద్దాం. అంతవరకు చూస్తూనే ఉండండి సాక్షి తెలుగు ప్రజలు మన సాక్షి. నమస్తే.